Hello, everyone. Good afternoon from my time zone here in Toronto, Canada. It is a beautiful day here in Toronto. And today we are here to discuss about the rule of law. We are presenting the rights of Canadian and Nigerian citizens who are married to EU citizens to reside in the European Union. So we have Barrister and Fred Ogiriake here today to discuss about this topic. Thank you, sir. Thank you for joining us today on the program.
I'm very pleased. Thank you for having me.
So, sir, before we start the program, I know that the audience will be willing to know a little bit about your professional life.
Yes, I started studying in Ireland approximately around 2000, the year 2000. I'm an Irish citizen. I did quite a few number of law degrees. Did my master's degree in Ireland. And then went to the law school in Ireland, the Honorable Society of the King's Inns. I was called to the Bar of Ireland in 2020. I've been practicing since that time as a barrister in the Republic of Ireland.
You know, your antecedents is very impressive. I hope that will inspire the younger generation to follow suit. Well done,
Yeah,
sir. So, what countries in Europe under this European Union, I would say?
well, there were previously 28 member states within the European Union. With the departure of the United Kingdom, we now have 27. And those 27 member states are Estonia, Austria, Italy, Belgium, Greece, Finland, Portugal, Spain, France, Cyprus, Netherlands, Germany, Slovenia, Poland, Bulgaria, Slovakia, Luxembourg, Czech Republic is there, Malta is there, Lithuania is there, and you also have Latvia, and there's Hungary, there's Croatia, there's Denmark, and of course there is Sweden and the Republic of Ireland. So those are the 27 member states of currently the 27 member states of the European Union.
And the United Kingdom just left the European Union recently, right?
Yes, they just did. They just did, yeah. I don't want to go into the dive deep into the legality of the rights. I would attempt to make the subject matter, explain it very simplistically, so that your audience might grasp the essence of the topic. Now, there is a directive that currently regulates the rights of citizens of the European Union. So if you're married to, say you're a Canadian citizen and you are married to a citizen, be a male or a female, of these 27 member states that I just mentioned earlier, and or you alternatively you are a Nigerian citizen who is married to any citizen of these member states that I mentioned earlier, the question then stems from what are the rights that you derive, or what are the rights that you may acquire by virtue of being the spouse or family member of a citizen of the European Union. That is any of the 27 member states I mentioned earlier. Now, there used to be formerly a regulation, which was the Regulation 1612/68. But that regulation now has been renumbered as Regulation 492/2011. And this is due to the extensive amendments that was made to European Union law. At the moment, there is a Citizens Directive. Now, the Citizens Directive is Directive 2004/38 EC. Now, what the provision of Article 7 provides is that as a Canadian citizen who is married to any citizen of the European Union, you can reside within the European Union. In other words, the right that you derive, that you have as a Canadian citizen who is married to a citizen of the European Union, is derivative in nature. Now, when I use the word derivative in nature, I mean that your right is contingent on the right of the European Union citizen. So the question is, what happens? How do you derive this right? So the European Union citizen would leave Canada, to search for work in the European Union. Now, when he is searching for work, the spouse have the right to accompany him to the European Union to search for a job. Now, the provision provides that the searching for job has to be a genuine effort. In other words, you must be really looking for a job. So you don't just have to come into the European Union and decide, well, I'm just going to pretend as if I'm looking for work, whereas you're not genuinely seeking work. So the European Union spouse come back into the European Union, and you accompany that citizen into the European Union, and they're looking for a job, and you're looking for a job at the same time. Now, the rule provides that you have that right to reside within the European Union with your spouse for a period of, say, 3 to 6 months. It used to be 3 months, but by virtue of the decision of the European Court of Justice or the Court of Justice of the European Union in the Antonisi case, you can now stay and search for a job within the EU for at least a minimum of 6 months. Now, if you are able to find a job, you then find an accommodation. Once those two are satisfied, your family member, which would include your direct descendants, that's your children, the direct descendants in the ascending line of your spouse, and yourself, can join you in the European Union to reside here. Now, the question of what resident permit do you require to immediately commence work? That is quite an interesting narrative, because under European Union law, the right to reside rests on the EU citizen. So the right to hold a resident permit is a mere formality. So the fact that you've not been accorded or granted the resident permit is not a yardstick for the member state to deny you any right under the European Union treaties. So you can immediately start work, your spouse can immediately start work, and your children can access any sort of educational or vocational kind of courses within the European Union. So that's the preliminary first stage of approach, that a spouse of yours leave the European Union, leave Canada to come to Europe, with you accompanying him or your children joining him. And then at that stage, your spouse, who is the EU citizen, is able to secure a job, have accommodation that is suitable for the family, but that requirement cannot be subject to any discriminatory measure. So it is a requirement that applies just as it applies to national of that member state. So you have a house to put a roof over the head of your spouse, your children. That is all that is required. There is no extra requirement or the imposition of any kind of discriminatory measure on the part of the member state. Now, after you've replied, yes.
I have one quick question there. If, for instance, I'm a Canadian citizen, I'm married to a German citizen, so my husband and I can decide to stay in France.
Of course, because France is a member of the European Union. The exact same right that you would acquire, because now there is this whole narrative that you must move from Germany to another member state to trigger European Union law. So you cannot derive a right under European Union law unless you've triggered your right to free movement. So yes, you're coming from Canada with your husband to the EU, and you decide to stay in France. By virtue of the fact that your husband is a German citizen, you automatically derive a right under the EU treaty. And you can stay in Germany as long as he is exercising treaty rights by working and residing in France. That right remains perpetually. It remains perpetually as long as he continues to exercise treaty rights by working and residing in France.
So the same thing applies to, I'm not sure if the same thing applies to Canada. If, for instance, a Canadian citizen married or a European citizen, Canada is different though. I cannot use Canada. No, it's different. The law is different here.
Yes, unlike Europe, yes. It's quite a different kind of regime. It talks about freedom. The whole essence of the European Union Treaty and its directive and regulations is not only to regulate the exercise of the movement of persons and services and goods across the European Union, but also it does espouses to a very large extent this entire concept of freedom. So it's freedom of movement, it's freedom of establishment, it's freedom to provide services, it's freedom to establish yourself within the European Union. And from the judgments of the Court of Justice of the European Union, which to some extent they drafted very clearly, does clearly spell out that resident requirement as could be imposed in Canada or in America does not really hold water in the EU. So if you're married to a European Union citizen as a Canadian citizen and you are resident in France or even in the Republic of Ireland, as long as he's started working, he started residing here, you automatically derive a right from his rights and you can immediately start working as well. And every right that applies to him applies to you, mutantes mutandis. And there are no grounds for discrimination. And of course, we have, yes, go on.
Even though you have no citizenship, because if, for instance, I'm married to a German man, and the German man is a citizen, of course, is a citizen, and
Right.
me, I'm just married to him. I don't have the citizenship yet, so I have the same rights as my husband in
Yeah,
Europe.
in Europe, yes, exactly. Exactly. Explicitly you do. Now, and that is the whole concept of the right being derivative in the initial period of your stay. So that right is derived. The same right that European Union law accords to your husband is the same right that you have. The right to work, the right to access education, the right to vocational training. As long as your spouse, your husband, is exercising treaty rights by working and residing in that member state, those rights are automatically conferred on you without any kind of discrimination. Now, after having resided in the European Union, so if you submit an application to, say, the member state in question, you then provide proof that your spouse is working. You also provide proof that your spouse has an accommodation that is suitable for the family. You provide your Canadian passport. He provides his EU passport. He provides maybe proof of residence, like a bill, a utility bill. And then those documents are then submitted to either the department or the institution that deals with immigration matters in that particular member state. Now, there is an obligation on the member state to assess that application within a period of 6 months. Now, that's the limitation period of 6 months, that they must get back to you with a reply on that application within 6 months. Now, under the provision of the new directive, now the directive provides very clearly that you are entitled to at least a minimum of 5 years residency permit. Now, like I stated earlier, the right of residence is not contingent on the possession of a resident permit, and that the right of residence rests or reside with the EU national, irrespective of whether they've given you a resident permit or not. So you could do whatever you want to do as long as your EU national is there. But to consolidate your residency, say if you require a residency permit, these are the procedures you follow. And when the member state considers the application within a period of 6 months, you are granted at least a 5-year resident permit in that member state, right? So that will enable you to travel, to reside, and perhaps, to go on holidays back to Canada for 3 months and to come back to the European Union for that duration of time, after that duration of time as well. Now, after you've resided for 5 years, now this is where it starts getting very interesting. There are
So
others, yes,
I have one quick question. So
yes.
I can only stay outside the European Union for 3 months in that case, right?
In that case, yes. Now, that is because when you're going to Canada now,
Mm,
right, like you're traveling to Canada or America, the rule
mm,
that applies is the Canadian rule. So Canada would only allow European citizens who are coming into Canada to be able to stay there for 3 months. I think America is the same. So it's a different kind of regime. But because your husband is a Canadian citizen and you're already a European Union citizen, perhaps you already have some kind of residency in Canada, that could be a very different issue altogether. But I don't want to go dive into the Canadian aspect of things. But I know as a European Union citizen married to, say, Canadian citizen or a Nigerian citizen, if you want to go on holidays in Canada or in America, there's this 3 months requirement as I know it to be. I don't know if that has changed, but that's the rule. But I don't want to dive into the Canadian aspect of rule. I just want to focus and limit the discussion to that of the EU, the right of residence under EU for now. So if you're a Nigerian citizen, the rules apply mutantis mutandis. In other words, it applies the same. So if you are a Nigerian citizen, you're a resident in Europe, right? So I'm not going into a situation where you're a Nigerian citizen, you married a European citizen in Nigeria. You have to process that application at that member state's embassy in Africa. So they process it there, and they give you the visa there to come to her member state, or the lady submits the application in her member state. That's a very different issue because that's wholly an internal situation. But when you say, if you are married to a German citizen who came to Nigeria on holidays, and you form the relationship with her, and she's working in France, then she has the same right as the Canadian citizen that I just explained. So she could require a visa or some kind of travel document for the Nigerian citizen to join her in France. That is one situation. Now, the second situation is where the Nigerian citizen is already in Europe, either as a refugee or as an asylum seeker, in which case we regard them as somebody who doesn't have a right per se to reside in any of the member states. So the Nigerian citizen is in France and meets a German citizen in France, and then solemnize a marriage ceremony with this German citizen in France. That Nigerian citizen, although he's a stateless person or an asylum seeker and has no right in France, automatically upon marriage, upon the validation of a solemnized marriage, and that marriage is recognized by law under French law, that Nigerian citizen derives a right from that European citizen from the day they solemnize that marriage. So from that day onward, that Nigerian citizen can seek work, has a right to any kind of employment, and the same rights that nationals of that member states have, that Nigerian citizen has, the same right that the spouse of that Nigerian citizen have is what he has as well. So the rights apply the same. So that's the way it works. And like I said, the right is not contingent. So the fact that someone would regard him, well, he's illegal, he's a refugee, he doesn't have any kind of right in France. From the day he marries the EU citizen, a right arises. And the right that is conferred on him is a right that arises under European Union law. And it is irrespective of whether he has a valid work permit in his Nigerian passport or not. But like I said, there is a provision under the Citizens Directive 2004/38 EC for him to submit an application with all the supporting documents to the member state in France to be conferred with a residency permit. Now, the European Union citizen does not require a residency permit because their passport confers automatic right of residence in any of the member states of the European Union.
Interesting. So one other question, guys, if you are watching right now and you want to call in, the telephone is on. You can call in and ask your question. Meanwhile, I have this question, it's a little bit critical, sir. I'm a Canadian citizen. I don't need a visa to visit Europe, but as a Nigerian citizen, it requires a visa to visit Europe. Why
Yes, because one, Nigeria probably does not have that kind of international agreement with some of the member states. I will take, for instance, in 1950s, 1960s, Nigeria has a very special arrangement with the UK, so that Nigerian citizens can travel from Nigeria to the UK without the need of a visa. South African citizens today can travel to Europe without the need of a visa. But you know yourself, situation transpired where those arrangements became obsolete. So Nigerian citizens, Nigeria, by virtue of not having any collaborating agreement, international agreement with any of these member states within the European Union, does render the rights of Nigerians to leave Nigeria without a visa to travel to any of these member states, except in some of these Asian countries, like Dubai or some of those countries. I don't think there is any member state within the European Union that allows Nigerians to just board the plane without a visa or a requisite requirement, satisfying the requisite requirement of travel to enter the European Union. I think that the days of that,
It's over.
has gone. It's gone. But you have countries like, of course, South Africa. I know they have a free entry. That situation is still tenable in South Africa. So that's the position at the moment. So that the only way Nigerians can travel, you have Nigerians who were born in Europe who relocated to Nigeria. Their situation is quite different. But when you're talking about a Nigerian citizen who has no connection, no links with Europe, now the right requirement is to obtain a visa, either a student visa, which some Nigerians would usually get upon paying the requisite fees into a university in Europe, and they will travel through, get the visa from the either German embassy or a British embassy, and travel to Europe. Alternatively, like I said, if you have a family member who is a European Union citizen and you form the relationship with that person in Nigeria, and that person is willing to support an application at their embassy for you to travel to Europe. Well, these are the only mistake. There may be other schemes, other visa schemes, which I do not want to dive into at this particular time because they outside the remit of our discussion today. But that's the way Nigerians could travel. Alternatively, they come into Europe as asylum seekers or refugees. And of course, you know quite well about the situation that is going on in Libya and the unfortunately the very high rate of death of Africans, not just Nigerians, Africans in generally who are trying to come to Europe, and some of them getting into Spain, and of course Spain, agitating that the numbers of these immigrants coming into Spain is overwhelming the facility in Spain. But again, that's another discussion for another day. But that's the way it works at the moment, anyway.
Interesting.
Hmm.
Wow. So I know that right now in Europe, it's like the countries, the seven members
The
of
27 members, yes. Mhm.
27 members are like very united. You don't need a visa to visit France from Italy. You don't need a visa to visit Germany from France, something like that. That is what is going on in Europe right now. As a European citizen, you have the right to, for instance, you are in France, you can migrate to Holland and seek job employment
Yes,
in Holland in within 3 months, right?
yes, of course, within 3 to 6 months. As long, again, there's always a caveat. When these provisions are enshrined or when a judgment is made, there's always a caveat that, as long as the search for work is genuine. So you cannot come under the pretense that you're looking for work, whether you're playing, whereas you're playing football, day in and out in a football pitch around the corner, or you're attending nightclubs and puffing away. That would not constitute genuinely seeking work. And I think in some cases, the immigration authorities would even want evidence to show that you're genuinely seeking work. But yes, as you've just stated, citizens of the member states of the European Union have the right to leave their member state and their family members to another member state for the purpose of seeking work there, for the purpose of getting to work there, for the purpose of staying there, you know. And of course, I wanted to go into the other dimension of the right of residence. After you've stayed there with your, say, Canadian citizen or Nigerian citizen for a period of 5 years, you now have a permanent residence. Now, these permanent residence enables you to stay in that member state perpetually, that is indefinitely. Now, the permanent right of residence does not allow you to, as say, for instance, there is separation or there is some kind of disunity between you and your spouse. There are provisions in the directive which I would leave for another day, how you can retain a right even when you're separated or when you're divorced from your European Union spouse. So there are protection, hence this whole narrative of freedom, But even if you separate, say you married you accompany your Canadian husband to France, and then while you're living in France, unreasonable differences arises where you could no longer live together as a couple, and you then decide to go and live in a separate accommodation. I can confirm to you that your right of residence is secured insofar as that Canadian citizen continue to exercise treaty right in that member state. So it doesn't matter. So it's a very unique dimension of the law. So it doesn't matter where you are living in that member state, as long as you can show that your Canadian husband or wife is still in that member state. You can live your life anywhere within that member state you want to live in, which is quite unique. And it's a concept of freedom. Whereas under domestic law, say you are in your member state, a requirement could be imposed that, well, you must live with that spouse for a particular period of time. Once that relationship ends, your right of residence ends. It is not the same under EU law. So as long as that European Union citizen is in that member state, where you live is irrelevant and immaterial. And that's the case called the Diata versus Land Berlin case, which is a German case. And that has been very extensively argued within various courts within the European Union. And that precedent stands to today. So it doesn't matter. If you
What
go into
about
the
what about if my husband, for instance, I'm married to a France citizen, so we are in France, and my husband decided to leave France. Why I'm not a citizen yet? I'm just a permanent resident or just married to my husband, wherever
very good.
I have. So in that case, if my husband went to Germany, stayed in Germany while I'm still in France, so what will happen to my own status there in France then?
Very good. Now, there are three stages, and I'm going to take this from three stages so it's very clear. If at the first, say, when you just submit your application for residency, and like I said, you're given the first 5 years, and before the expiration of that 5 years, your European Union citizen spouse leaves that member state. Unfortunately, because your right of residence is derivative during this period of the 5 years, your right of residence become very problematic in that member state. In other words, that could, to some extent, affect your right of residence in that member state. Now, there are situations where maybe you've spent over, I think normally spend a few period of time or years in a member state when you can retain a right. But if you've acquired the permanent right of residence in that member state, and then the EU citizen spouse decide they were going to leave that member state and abandon you in that member state, I can confirm to you now that you have a right to stay in that member state perpetually. And that the fact that after acquiring the right of permanent residence in that member state, that your union citizen spouse leaves that member state is irrelevant and immaterial. And I can confirm that because I have a personal matter of mine that I brought before that was referred to the European Court of Justice that and it's a very personal experience. The European Union citizen, after a period of 5 years, decided they were going to leave Ireland back to France. And there was a dispute as to whether I still retain my rights as a permanent resident in Ireland. The European Court of Justice, or the Court of Justice of the European Union, as is currently known, unequivocally decided that that right continue to rest with me, irrespective of the fact that that your citizen spouse has left the Republic of Ireland. And I mean, if you Google my name, you're able to access the judgment, and the judgment can assist any, and that judgment applies to the 27 member states of the European Union. So that is the dichotomy between having a right in the first period of 5 years and having a right of permanent resident. That right is permanent. In other words, it is an acquired right. It's a right that you acquire within over a duration of time, and that right cannot subsequently be altered or rendered null and void by virtue of the new citizen leaving that member state.
Member states.
That's the way it goes.
Oh, interesting. This is really interesting.
Yes.
Wow. Which means if, for instance, I'm married to a France citizen and my spouse decided to leave France, maybe there is a kind of conflict between myself and my spouse, which means I will still maintain that rights of a permanent resident in France, even
Yes,
though my spouse left France because of the conflict we had or something like that. So yeah, the
exactly,
my
exactly.
rights, my that would be like my residence rights will still stay in France. But after 5 years of residence in France, will I be eligible to citizenship?
Exactly. That's a very, very interesting question. Of course, you will be. So, so by virtue of the fact that you are now permanently resident in France, often applications for citizenship, save for the fact that there are no allegation of criminality, that you've not engaged or you do not have any criminal records in France, and that you've had very clean records. You've consistently worked within that period of time. You've been resident. In other words, you've not been absent. Now, there is a provision. I must mention this here now. There is a provision that provides for the time when you can lose the right of permanent resident, and that relates to period of absences. Say so, your spouse left, you went to Canada, and you
Mm,
decided you were going to stay in Canada for over 2 years. You will automatically lose your right of permanent resident. If you decide to go to Nigeria and not return back to France after 2 years, and the French authority became aware that you were not in that member state, and or somebody provides information or information gets to the French authority, I'm sorry to say, unfortunately, the French authority might seek to revoke your right of permanent residence. Because the right of permanent residence, although it grants you an independent or autonomous right to reside in France, there is a requirement that you must continue to stay in France and you cannot be absent for a period of 2 years. Quite
yes.
reasonable, which is quite reasonable. And I mean, if you say a member state where you've resided, you've formed a family, you've lived there, you work there, I don't see any reason why you want to leave that member state for more than 2 years, which to me is reasonable. Now, back to the issue of citizenship. Insofar as you have proof that you've been there for 5 years, and normally this applies generally under European Union law to other member states as well, you could submit an application to become a naturalized citizen of any of these member states within the European Union, as a person who is married to a national of that member state, and there's no discrimination. I submitted my application for citizenship in Ireland after having spent 5 years as a person who has acquired the right to permanent residency. I didn't
Mm,
have any issue. I got my Irish citizenship. I still continue to hold my permanent residency under European Union law because they're two separate legal dispensations. So the right to permanent residency remains perpetually, just like the citizenship remains perpetually. So unless, like I said, you leave the member state for a period of 2 years, or
yes.
there are grounds, there are issues that undermines public policy, or that undermines public security, like you become a member of Boko Haram, and and then there is this proof that there's this proof that there's a propensity within you to commit havoc, or to commit serious terrorist offenses against the state, then you'll be in very serious trouble. And that could sometimes result in member state refusing your residency. And even sometimes if it's quite extreme, you have member states trying to revoke citizenship,
Mm,
where you constitute a continuing threat to public or national security by virtue of some terrorist activities that you're carrying on within that member state. But if that is not there, I think it will be very, very easy for you to invoke the citizenship laws of any of these member states to seek to naturalize as citizen of that member state.
once you gain your citizenship in France, for instance, can the government or any case lead to the revoke of your citizenship?
Well, it is difficult once you have citizenship of a member state. But like I said, I know of cases where member states would attempt, but it is quite difficult. Otherwise, arguments could be advanced before a court to say that, let's take for instance, a person who was born in France never had any connection with any African country or any member state. As a matter of fact, there are decisions made by the European Court of Human Rights that prohibits such attempts. But there have been attempts. But I would say it is less likely to succeed, because to render people stateless is a breach of human rights itself, particularly when that person has previously established and has become naturalized or is a citizen of a member state. It's like saying, oh, well, you want to deny a Nigerian citizen of his Nigerian citizenship, whereas the Nigerian citizen is born in Nigeria, has no connection in Ghana or any other member state. That's a fundamental breach
No,
of human rights. So I don't think that is possible.
no,
But
no, not that. I'm not talking about a Canadian citizen, for
mm,
instance, that was
mm,
born here in Canada, that
yeah,
they can never revoke such citizenship because you don't have any other state. But I'm talking about someone like me, for instance. I have two
mm,
citizenship in
yeah,
Nigeria. I'm a Nigerian citizen, also a Canadian citizen. In this,
mm,
in the case of any conflict or any criminality, can the
mm.
Canadian government revoke my citizenship?
That's what I'm saying. That it's quite difficult because it is discriminatory. Now, don't forget that you a European Union citizen, by virtue of the fact that you hold European Union citizenship, arguments could be advanced under European Union law that you cannot discriminate between citizens of a member state and European Union citizens. So the argument would be, now you cannot revoke the citizenship of one of your citizens. You cannot attempt to revoke mine because I have the same right as your national. And I
Hmm,
think that is where the difficulty lies. So
hmm,
there are lawyers who are experts in this field, like myself, who could go into court and advance arguments either under domestic law, under EU law, and of course accompanied with the ECHRO, the European Court of Human Rights rules, to say that to apply such a measure would be discriminatory because the right was acquired under European Union law, and irrespective of the fact that the right was acquired under European Union law, that such measures are discriminatory. And the example can be given logically to say that if a member state cannot revoke the citizenship of its citizens, that member state cannot revoke the citizenship of a naturalized citizen. Now,
hmm.
I also mentioned earlier that the member state might seek, depends on the height or the level of the threat. So it is not a legal alternative that is open to a member state that they can just invoke willy-nilly. So it's not something you could just evoke willy-nilly. It has to be, the action of that person has to constitute a genuine threat and is a continuous threat. Like it's so serious that it absolutely undermines national security. And even if that is established, you still have to jump or satisfy the hurdle that such a measure is not discriminatory. If it's a measure that you cannot apply against your citizens, I don't think you can apply it against a naturalized citizen, and I think it will constitute a breach of human rights. And I don't think if it goes before the European Court of Human Rights, that court, or even the European Court of Justice, that court would, decide otherwise. So it is quite is an arguable case, but
Yes,
it's less
exactly.
likely to succeed. But it's quite difficult. I haven't heard of a situation where that has happened. I know that there are cases where the European Court of Human Rights and even the European Court of Justice has frowned against proceedings where member states try to render null and void the citizenship of individuals.
Exactly, exactly. Because as a Canadian citizen, I possess the same rights with those that were born here in Canada.
Exactly.
So, no matter the degree of crime that that person commits, it does not justify the Canadian judicial system to revoke the citizenship of that person, right?
It works exactly the same here. Exactly. Now we're thinking
Mm,
logically the same. It works exactly the same here. And I don't think, I don't think it's what the member state. They probably, if you commit a crime, they lock you up. I know, as long as the same penal system that deals with the national will deal with you. If you constitute a threat, there are provisions under domestic criminal law for you to be reprimanded somewhere. but that is subject to natural and fair procedure and justice. That you be locked somewhere, as opposed to the member state resorting to revoke or render null and void your citizenship in that member state. Yes, absolutely correct.
Yeah, exactly. Thank you so much, sir.
Thank you. Thank you.
Okay, we are almost 50 minutes here. Thank you so much for today's discussion. Next time, what topic are we going to discuss about? I'm looking at the UK leaving the EU. It's a
That would
very
be
interesting
yes, that
topic.
would be an interesting one.
Mm.
So we'll talk about that off camera, and then we can schedule another date subject um, to my convenience and your convenience, and then we schedule and we discuss it as we did today.
Thank you so much for this awareness today.
Thank
I
you.
hope the audience love this, and I will do another rebroadcasting this program again tomorrow, Sunday,
Very good.
so that the audience they will enjoy watching this lecture. Thank
Mm.
you so much, and
Thank
we are
you.
looking forward to host you next time.
Thank you very much.
Especially this topic that I'm very, very interested in. The
Mm.
UK leaving the EU is very important that we
Mhm.
know why their justification, the reason, the complexity, everything
Mm.
behind this notion of leaving the EU is a big thing. So we're gonna be discussing about that next time. Thank you so
Thank you
much
very
and
much.
have a wonderful